Welcome everyone. It's good to see that we have already over 40 people here, and I suggest that we kick it off today. Welcome everybody. My name is Henri Ratnik. I'm the co-head of our IT, data protection and cyber security law team here at WIDEN Legal Estonia. It is my pleasure and honor to introduce and kick off this lovely webinar here today. Couple of words also from about our hosting law firm WIDEN Legal. As you probably know, we have offices in Estonia, Latvia, and Lithuania, which also helps us to provide this unique experience for you today, all listeners. So you get an insight about the new cybersecurity directive from all Baltic states. We have altogether 130 people already working in our firm. We have been growing quite heavily, about 20% in a year in the past years. So we're doing very good in this front. And we are covering each and every sector and field of law. We are, of course, especially good and professional in IT and data protection and cybersecurity law, but other teams are doing very good job also in other fields of law. So we are providing legal services in all fields like M&A, litigation, criminal law, employment law, of course, and all types of law. And we call ourselves the Legal Jazz Company, which means that we play together as a team, good, very professionally, as any jazz ensemble would. We are good at playing solos, but we are also very good at listening to the clients and other team members. To kick off our lovely cybersecurity webinar today, I would like to give you guys a quote. It's a quote of Warren Buffett. It says that it takes 20 years to build a reputation and 5 minutes to ruin it. If you think about that, you'll do things differently. And you may ask, Henry, what is a quote from Warren Buffett doing here? Warren is not a cybersecurity guy. He's not an IT guy. He's a rich guy. He does investments. But the thing is that this quote also suits perfectly for cybersecurity world, because if one has a problem, if one has a data breach or something like that, and the customer's data is leaked, is out in the open, then getting a fine from the regulator is one thing, but losing your reputation is other thing. And if one loses the reputation of its customers, its clients, its cooperation partners, the data leak is all over the media, then it's very difficult to build your business and continue your business as it was. We have a real world example. For example, in Estonia, we had data leak by one of the companies who handled very sensitive medical data. All major clinics and hospitals send their patients' data to this processor. This processor was doing like laboratory genetic analysis. They had a data leak. And when I this morning looked at the revenue of that company who had that data leak, I saw that their revenue has fallen over 50%. And this is a real life example what happens regarding reputation and business if there is a cybersecurity problem. And before moving on to today's webinar, we are extremely proud today, here and now, for all you lovely webinar listeners to announce our new service. The service is 24/7 legal hotline for cyber attacks and data breaches. We have a dedicated phone number. It's possible to call there 24/7. It's meant for people who have, for companies who have a problem, who have a cyber attack, for example, or their data has been breached, or they are suspecting that there was some kind of attack or breach. The reason why it's open 24/7 is that these situations are very, 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 and one more time, very time sensitive. The notification periods, which we will talk about later, are extremely short. The the things that you can do in the first hours are the things that you may not be able to do in the next days. So this is why we're launching this new 24/7 legal hotline service. Further information is available on our website. There is also a link here. You can click on it. You can check it out. Of course, the first feedback, the initial feedback is free. It's on us, so to say. And all calls are, of course, 100% confidential. So if you have a problem, then please do not hesitate and call this number, and our professionals will handle it. But to move on to our today's agenda, we will be talking about the following subjects. So today's webinar will last about 1.5 hours, and we will cover the following subjects. First of all, it will be introduction to this new NIS2 directive by our good colleague Asta from WIDEN Lithuania. Then Anete, a good colleague from our Latvian WIDEN, will talk about the criteria for determining essential and important entities, meaning that who is actually subject of the new directive. Then Asta will once again talk, and she will talk about the cybersecurity risk management measures and supply chain security. Then as a fourth topic, I will talk about incident notification requirements. And as a final section of our today's webinar, good colleague Rauno Kinkar from Estonian office will talk about enforcement measures and penalties. So a very juicy topic in the end as well. And of course, if you have any questions, please do not hesitate to ask them. We have a specific Q&A function here at Microsoft Teams, so please write, and we will answer these questions. It will be very good to hear your questions and have this kind of dialogue. And please use this opportunity, because we have experts from 3 Baltic states here. So I am confident that we can answer all the cybersecurity law questions that you have. But without further ado, I will give this virtual floor to Asta. Go ahead. Asta, you're on mute.
Thank you, Henri. So I'm Asta Macijauskienė, cybersecurity law expert in Lithuania. And I will share some thoughts about, in general, why NIS2, what is the difference between NIS1, nobody calls it, but I will call it NIS1, differences between those 2 directives, and why itself we needed this regulation. So first of all, I think that even my colleagues didn't know the fact that one of the first larger cyber attacks occurred in Estonia. Guys, did you know that? Yeah, so it was one of the largest cyber attacks in Europe. It occurred in 2007. The society encountered a conflict regarding the removal of the bronze sculpture of Soviet Union soldier. Because politicians wanted to remove it from the center of the town to some other place, and Russian people were against that, and it was a mess. They argued, why do we have to move it? And at that moment, the cyber attack occurred. It was designated to disturb the performance of official websites of banks, and it was a time period when the services provided via website didn't work, of some serious institutions, banks, and other entities. So this was the significant cyber attack, which was initiated the beginning of talks. Do we need some laws? Do we need some regulation in all the Europe? And afterwards, in 2008, 2009, 10, cyber attacks went larger and larger, and it was more often than it was before. And it was designated to disturb the operation of gas services, other services that are crucial to society. So then at that moment we had NIS1. It was not called NIS1 at that time because it was the only directive that regulated cybersecurity. And then afterwards we had COVID, and experts say that NIS2 was the result of COVID and the consequences it posed. It means by when we had COVID, everything was closed. And people were sitting by the computer, they were angry, they hadn't social life, and they were searching what to do, how to entertain ourselves. So experts say that it was the larger number of cyber attacks, of cyber incidents, was the consequence of COVID, of sitting at home and having nothing to do. People who were not treated like criminals, hadn't any criminal activity records in the past, started to do that. So it was a huge rise in cyber attacks, and we needed a NIS2. We needed stricter regulation, which was very different in all the countries. So we have to move to the next slide. And now what differences do we have comparing NIS1 and NIS2? This directive covered more sectors because the practice showed that it's not enough. It's not enough. We have to add some additional sectors. Now we have more detailed provision on incident reporting process, content and deadlines for notifications. For everybody have to notify about significant incidents. Some countries like Lithuania have to report on other incidents as well. We have a detailed procedure how we have to do that. Before, it was regulated differently in different countries. I should say that now we have also different things in all jurisdictions, because, for example, as I've mentioned, we have to report in Lithuania about other incidents, and for example, in Latvia and Estonia, we don't have to report on other incidents, or maybe we will have in the future when the laws will be implemented. But at this point, we do not have to. You do not have to do that in Estonia or Latvia on other incidents. Meaning, so. We have differences. The directive was designated to eliminate these differences, but now we're talking about different terms, different categories of incidents. What we have additionally in NIS2, we have periodic audit duties. We hadn't it before. NIS2 addresses supply chain security and supplier relations. We did not have that in detail. We had internal rules of different companies, of different group of companies who were who wanted to secure their supply chains, but it was not like direct obligation established by the laws. Now we have that. What else? What differs for NIS2 from NIS1? It's like now we have stronger supervisory measures for national authorities. We have removal of CEO, for example, in Lithuania, suspension of activities. What else? fines are increasing. Yeah, we had funny fines in Lithuania, and nobody was afraid of cybersecurity fines. Now everybody's afraid. If you are a subject of cybersecurity, you must be afraid of fines because they're huge. We will talk about that later. So these are major differences, and now let's move to the next slide, where Anete from Latvia will introduce what are the criteria for determining essential and important entities. Anete, the floor is yours.
Yes, thank you very much. Hello, everybody. Hello from Riga, Latvia. Yes, today I will speak about essential and important entities, and also about what kind of entities are covered by NIS2. Maybe just a reminder that we should all check once again whether this regulation is applicable to us. However, I would like to start that in general, there are two types of people in the world. Those who always buy a ticket because they are sure that they will be caught. And the other type is the people that had been riding for free since 1995 and think they are basically invisible. If I could offer for you the cloak of invisibility, I could, of course, try to provide you with that. But, I'm not a magician, and all the lawyers are not magicians, unfortunately. Therefore, what we can do, we can provide you with the information that you could check, and also feel free to ask us. We will be happy to help you to understand if the NIS2 is applicable to you, and if yes, what kind of requirements you should fill out, and what you have to do if something happens. Rauno will later talk about the fines, but the main thing is not the fines. It's actually our all safety.
The fines are the main thing, for sure. Do not listen to Anete.
Yes, but okay, Rauno, but NIS2 also covers such sectors as, for example, drinking water and producing of food. And if we are looking of Maslow hierarchy of needs, the food and the water is the things that we all need. So even before we will have to pay the fines, we will have to eat something and drink something. So this is not only about the fines, and in what kind of situation we are currently, what is happening in the world, and so on. So it's important to actually follow the rules and to keep everyone safe. So let's start with the thing, where should I read if it's about me? So we will be talking about NIS2. This is the long name of the directive. All the countries have made it shorter except Estonia. So TID2 directive, TID directive in Latvian, TIS2 directive in Lithuanian, and then there is long word that I will not try to read in Estonian. So there are also short names and a bit longer in Estonian. But as you might know, directive is one type of the legislation documents from EU that is not directly applicable, but every country needs to implement it in their own national laws. Currently, Latvia had informed the EU that we have implemented it in a kiberdrošības likums or in a cybersecurity law. Lithuania had gave the information that it is implemented in 22 different legal acts. And Estonia is not implemented it yet, but Estonians showed me that they are on the way, and hopefully soon it will be implemented as well. We can make jokes, maybe, I don't know how many of you or Lithuanians are making the jokes about slow Estonians, but to be honest, when I was preparing, also Latvia is not that good as they're showing, because we are still waiting this regulation of Cabinet of Ministers, which will be the minimum cybersecurity requirements. We have not done that yet. And the last meeting was on May this year. And from the meeting, it is visible that the Ministry of Defense still have a lot of homework that must be implemented, is this regulation of Cabinet of Ministers. So it means, yes, we have in Latvia the law, but it's not enough. Still, we are waiting for a lot of technical things what the subjects have to do. What is the good part about the Latvia? You see the link in the end of the slide, and if you know Latvian, you can take this test, which will give you the possible answer if you are the subject of the law or not. I asked my colleagues, unfortunately, Lithuania and Estonia don't have such tests yet, but maybe in the future you will have as well. But yes, Latvians can take the short test to check themselves whether NIS2 and the cybersecurity law is applicable to them. But the first step is to understand what I'm doing. It might sound like an easy question, because of all of us, we know what we are doing in our job and what is our business is doing as well. But you should start with the 2 annexes, which cover all the sectors that are applicable to the NIS2. It might seem quite easy, but then you go to the annex and then you see that there is sector, subsector, and type of the entity, and which leads you to again to another directives that are applicable to your kind of business, or describing that this kind of business falls under the NIS2. But the good news is that if you already have some kind of the directive that is applicable to you, it might be the first sign already that NIS2 might be also your issue or possibility to work better. The second thing is also the size. The directive includes this term of medium-sized entities or larger. So the criteria are 250 people, the turnover, and or the balance sheet. But I don't know how many of you have tried to learn German, but it's quite similar. You know, when you are changing the words, sometimes there are some kind of grammar rules, but and then there are exceptions. And it's the same about the NIS2. Even if you are smaller, there might be situations when size doesn't matter. This is not a complete list. But NIS2 directive is giving these wide words in law. We are calling this general clauses. Why legislators are including these general clauses? It's related to that legislator is not able to explain every specific situation. So therefore, legislator is including in the regulation such words which is essential for the maintenance of critical or social or economic activities. It might differ from country to country. for example, significant impact of public safety. It might be different in different countries. Therefore, the legislator included such wide terms in the directive because it allows the national governments somehow to change the requirements and to make it specific for each country. Therefore, it's not like that you think, okay, I'm smaller than medium size. No, in some kind of situations, you might be also a subject of the law because of your specific importance in your country. The directive also says that by July 17, 2026, each member state shall identify the critical entities. So it's not all over, and let's hope that governments will help you also to understand whether maybe you are in this specific situation. The other two terms which are important is this essential and important. Why it's important? It's because the requirements will be different if you are essential or important. I have provided very short cheat list, but which might give you already the thought that you might be the subject. But as you can see, the cheat list doesn't include these specific situations when the size doesn't matter. But this might be already the first step to understand maybe NIS2 is important to you as well. The other thing, when we are talking about NIS2, this is a minimum harmonization directive, which means that each member state can provide higher level of cybersecurity. So it means when we are talking about NIS2, there will be differences between different countries, which we can already see from the cybersecurity law of Latvia. You can see that, for example, Latvia have included all electronic communication businesses. Latvia have included in the cybersecurity law also the companies that provide security services, maintainers of educational information systems. So there will be differences. The directive allows it. So it's not enough also for you just to check the NIS2. You also need to follow the national regulation. The good news, the competent authorities should be already contacted you because they need to make the list. They need to require the information from you. So this might be like a sign that NIS2 is applicable to you. The question, can I be both essential and important? Yes, you can. And even though maybe the sector that you are working is not the main, which it includes you in NIS2, you will be anyway the subject of NIS2. Maybe it's just a small part of your business, it doesn't matter. And if you are both essential and important, according to Latvia, you will be considered a provider of essential services. So the member states have to make a list, at least in Latvia. The list is not public. it is restricted information, so you won't be able to Google the list of the providers of essentials and important services, at least in Latvia. I don't know if it is the same in Lithuania and Estonia, but it might be. So the main points of how I want to end my presentation is that don't stay in the dark. Everyone will have to buy a ticket. Read NIS2 together with national legislation. Don't listen only what is happening in other countries. In your country, it might be different. Understand clearly the sector where you are working. Don't think only about the size, because sometimes the sector where you are working is more important. And the list might not be public. And if you need any help with understanding the requirements, and if you are or not the subject of the NIS2, please feel free to contact us and we will do our best to help you. Thank you very much.
Thank you, Anete, very much for this overview. So, yeah, if anyone has a question, like a good question, am I essential or important entity, then feel free to, ask it in our Q&A section, and we'll try to figure it out during our webinar, or if not during our webinar, then afterwards. But let's give a virtual floor back to Asta. Go ahead.
Thank you again, Henri. And now we will talk about cybersecurity risk management measures. The directive established a list of the measures that must be implemented by every cybersecurity entity. But what happens every time we have a directive, not regulation, not a very specific legal act, we have some details in national laws. And we have, in Lithuania, we already have the legal act implementing the cybersecurity law. So we have a detailed description of cybersecurity measures that must be implemented. It differs whether you are essential or important entity. We'll talk about the measures that must be established in all the EU countries. We will not go into Lithuanian detail, but firstly, I would like to bring into the light the main point of the implementation of cybersecurity risk management measures, that the concrete list of the measures you have to implement is based on the risk assessment that you have to perform. It's not like that you have to perform all the possible measures that you might find in the world. No, you have to perform risk assessment, and the outcome of that risk assessment should be the list that you have to implement, the concrete list that you can implement in your organization. The risk assessment, the result of the risk assessment will depend from the degree of the entity's exposure to risk. Whether you are, the entity which has all IT infrastructure 10 years before you were ready to implement everything, whether you have real good procedures to implement that you have in the documents, the entity of the size matters. Whether you are big or small, the risk level will be different, yeah? And the likelihood of occurrence of incident and their severity, including societal and economic impact, matters also. Taking into account all the scope, whether you are big or not, what data you process, what information you process, whether are you a healthcare institution, whether you are a very important state institution processing and managing very serious data. Everything must be taken into account, and it must be reflected in the concrete measures that you will implement. And the directive speaks about a list of security measures that are, must be detailed in national legislation. So what are the key points we are talking about? So you have to have policies on risk analysis and information system security. Everything must be documented. We had a conference on cybersecurity and data protection last month, and we had experts talking about the documentation and technical measures, and we came to the conclusion during discussions that documents will not help you. Mere documents will not help you. Although we have the requirement to have the internal policies, internal procedures, but mere documentation will not be a shield from the cyber attackers. So, okay, we have requirement of the policies. It's must. Okay, it's hygiene. You have to have that, but we have to talk about more about technical implementation. Second thing, incident handling. We have to have not only the procedures, but we have to teach people how to react. We have to check whether it works, and we have to have technical measures to detect incidents also. So this must be also established not only in the internal procedures, internal rules, documents, but have to be implemented in technical level. Business continuity. We have to have the business continuity plan, not like, a draft which I can buy in the market for 100 euros. It have to be adapted to your internal rules, and it must be serious. Incident handling plan must include all the actions, all the duties, responsible persons. They must know what to do when incident occurs. You must have backup copies which are tested whether it works or not. You have you have to know what are the tolerance levels of in performance of your IT systems. So everything about incident handling and the plan and the business continuity plan. Supply chain security. I will talk about that in more detail, but it's a quite complicated procedure that is not only the good contract with supplier. It's selection of the supplier, it's evaluation of the supplier, constant inspection of the supplier. We will talk about that, but you have to have it in documents and really perform it, really execute that internal rules. You have to ensure the security network and information systems acquisition, development, and maintenance. What does it mean? That you have to have the rules, how to buy new technologies, how to make amendments, what procedure should be followed when doing that. So this might be a part of a general cybersecurity policy or addendum to that or a separate document, but you have to align it in your documentation. You have to assess the effectiveness of cybersecurity risk management measures. It's like a new requirement, yeah, because documents okay, implementation okay, but added to that, you have to inspect whether it works. You have to have the procedure which established how you will check whether it works. What will you do when you detect that it doesn't work? To whom you will escalate that? So everything must be in place. And I know that in Lithuania, we have service providers that specializes in this service. They provide services of the assessment of the effectiveness. So if you can do that by yourself, just find a service provider who can do that for yourself. You must have the policies and procedures regarding the use of cryptography and where appropriate encryption. Yeah, it's like a hygiene, nothing new. Okay, you have to have this in documents, and you have to ensure that actually it is performed. Access control policies, also nothing new. Okay, we have it from the times of GDPR, and every entity process personal data. So if you now became a cybersecurity entity, cybersecurity subject, cybersecurity entity, so you will be you will have to adopt the access control policy if you haven't had that, which would be very strange, and implement it in reality. You must use multi-factor authentication. Also, it's hygiene, yeah, because we see that cybersecurity attacks are effective when you haven't multi-factor authentication in those companies. So it's like you must have that, you must have the rules, you must implement it in practice. There's no miracles, okay? These requirements are quite usual, except some few new requirements like supply chain control and security and assessment of effectiveness. About supply chain, we should talk more about that, because it's quite, like I've told you, a new requirement. It was not established in general used ISO standards. So we have like a new duty. Yeah, what do we do? Firstly, I would like you to recommend to read this NIS's recommendation, Good Practices for Supply Chain Cybersecurity, just to get more knowledge about how this procedure looks. Okay, it's a quite big document to read, but you will have some basic opinion what you have to do, what the procedure looks like. So it's the supply chain risk management cycle is composed of 4 main stages. The first stage, that in your organization you have to identify what services will be outsourced, what services will need the assistance of the service providers. You have to evaluate the risk that imposes, what measures you should implement to your service providers. And then only in next stage, you conclude agreements with these suppliers. According to the risk established in the first stage, you include these requirements in your agreements. Vulnerability handling is also important, because now you have the agreement, and this is the performance of the agreement, and you have to know the places which needs more attention. The fourth stage is that you have shortly, you have constantly control your service provider and check the quality of the services, whether it's okay, what's it is obliged to do, what is established in the agreement, whether it performs the agreement correctly, whether the services are of that level that we need. So not only the election conclusion of the contracts with the suppliers is important, but all the cycle of supply chain risk management. Talking about Lithuanian peculiarities, of course, Lithuania is the country that likes to regulate more than it's necessary, I should say, because from practice I see that other countries, you know, are not tend to regulate additionally to the level established in directive. We have in Lithuania such clause in law, in the legal act implementing law, that a cybersecurity entity shall, in its contracts with suppliers, including sub-suppliers, provide the following in relation to the services provided. What do we have here? Directive says that we have to control direct suppliers. In Lithuania, we have that we must ensure that agreements with our suppliers, including sub-suppliers, provide some obligatory clauses. So we have a very specific requirement to include something in the agreements with suppliers, and also to have ability to control sub-suppliers through these provisions of the agreements. So what do we have to include? Inter alia, we have to include the requirements for the supplier to comply with the regulations, to notify on major and other incidents. Okay, if we have the supplier in Estonia, for example, you don't have to notify the other incident to Estonian supervisory authority, but if the provider provides services to Lithuanian entity, it must notify the client on other incidents. Okay, so we have a stricter regulation here. The right to carry audit must be included in the agreement. You know, the list is very specific list what you have to include. And if you don't have that in your agreement, and if incident occurs, it might be that you will be under the breach of regulation, even to the fact that you didn't provide it in the agreement. So be aware of that and look at that list. This list is only general list for all the entities, but the regulation also includes specific requirements, which I did not include in this slide, for essential entities. Essential entities have additional requirements to be included in the contracts with the suppliers. So be aware of that, and we have already that in Lithuanian regulation. I don't know how it will be provided in Estonian or Latvian regulation, but if you have entity which is a cybersecurity entity in Lithuania, you have to be aware that at this moment, when you deal with agreements, when you deal with suppliers who provide services to cybersecurity entities, you must know these requirements. So that's it from my side. And Henri, the floor is yours.
Thank you, Asta. As we saw, there are lots of obligations, lots of documents that need to be drafted, and of course, documents only will not help. The technical stuff has to actually be in place, and employees must also be schooled, because of course I'm a lawyer. I'm not an IT guy, but as much as I have experience with different cybersecurity problems, in many cases, the person or the employee is the weakest link, because in many cases, it's not a virus that attacks the company through the firewalls, but it can be an employee who receives an email, which seems to be like an email from his or her boss or a co-worker or a client, which actually isn't a proper email, and is actually an email from a cyber criminal and has a malicious link into it. And then this person may put his or her login data to a false page or something like that. So schooling is definitely also important. But coming to the incident notification requirements, a large part of the NIS2 directive and also the previous NIS directive was the obligation that if there is a problem, if there is an incident, for example, a data breach or something like that, then this must be notified to the regulator. And where to start with these rules? Here is like a simple plan. First of all, you have to understand whether your entity is even subject to the NIS2 regulation. This was already covered by good colleague Anete before. If you are subject to the NIS2 regulation, then when there is a problem, or if there is some kind of thing that you think is like a cybersecurity incident, then you have to really understand, okay, do we have an incident? And also you have to understand whether this incident is a significant one. Significant has a specific definition. We will talk about it in a minute. After that, there is the notification obligation. We'll also talk about that in a minute. And in some cases, in addition to notifying the regulator in your country, you also have to notify the users. So the users of the service, the public, so to say. And when we're talking about NIS2 directive, we also cannot forget about other laws, because other laws like GDPR, for example, also has notification requirements. So we'll also talk about that in a couple of minutes. So the first question when we're talking about the line or the timeline, which is shown in this slide, is the question whether you are subject to NIS2. If you are subject to NIS2, you are an essential or important entity in the context of NIS2 directive, then you have to also understand whether you must notify the regulator in case of the incident. And when talking about the incident, you have to understand whether something is an incident or not. And here NIS2 provides the incident definition, which is an event compromising the availability, authenticity, integrity, or confidentiality of stored, transmitted, or processed data, or of the services offered by or accessible via network and information systems. Quite a long definition. So, but for example, what is an incident? Incident can be, for example, if you operate a hospital, if you have a hospital and the ransomware attack is performed against the hospital, like cyber criminals come into your systems, they steal all the patient's data and lock it away via encryption, and you as a hospital cannot access it. You cannot access the patient's files, for example. You do not have the timetable of patients coming in today for operation and so on. This would be, for example, an incident. Or, for example, if you have a distributed denial of service attack against a company, or, for example, like a ministry web page or public transport ticketing website, meaning like this is actually one of the things that happened during 2007 in Estonia. When we had the bronze soldier cyber attacks, is that a lot of requests came in from malicious users to use the web pages of ministries, and this is called the distributed denial of service attack. And because there are so many users coming into the web page, the web page crashes down because it's too much to handle. So, for example, this kind of scenario would also be an incident. And but we also have to understand whether of the directive, and the directive says that incident is significant if it has caused or is capable of causing severe operational disruption of the services or financial loss for the entity concerned, or it has affected or is capable of affecting other natural or legal persons by causing considerable material or non-material damage. What is important about this definition is, first of all, these two elements are alternatives. So if one of them is apparent, then the incident is a significant one. Second important thing is that the definition reads that it has caused or is capable of causing, and the other one, it has affected or is capable of affecting. So even if there is like a risk that this incident could be a significant one, then the rule of thumb is that it should be considered a significant one until we have further information. When we talked about these two examples before, the hospital which is hit by a ransomware attack and the website of the ministry, then I would say that the hospital attack is definitely a significant one because the patient's data is encrypted. It's not a large argument there whether it is a significant one or not. And the other example, when a ministry web page is down, this is more arguable, whether it's a significant or not. If the ministry web page is down, not maybe because of DDoS attack, but for some kind of other thing, like there is like a glitch in software or somebody pushes the wrong button and the website is down for like 5 minutes or something like that, it is arguable whether it's significant or not. My personal opinion, if it's down for 5 minutes and not because of malicious actors, then probably it's not a significant one. But this is this is a thing that the entity must do and understand itself. So if there is an incident or if there is suspicion of that there was an incident, then this must be internally assessed whether it's a significant one or not, within the meaning of the directive and the local laws. So what the directive reads is that essential and important entities have an obligation to notify the CSI RT, meaning the local cybersecurity regulator or the competent authority, and this must be done in case of significant incident. As Asta also previously mentioned, and I'm sure that Asta later on would like to clarify that, then in Lithuania, as you mentioned, Asta, Lithuanians like to put more regulations to companies compared to some other countries. So in Lithuania, there is also an obligation in certain cases to report a non-significant incident, but the directive itself states that significant incidents must be reported to the CSIRT or the competent authority of that country. And how does it work? How does it have to be reported? The exact rules depend on the country. Typically, there are, and in Estonia, for example, there is a specified, like a specific web portal where this notification can be done. There is also an email address which can be used to submit this notification. There are also forms which can be fulfilled to notify this incident to the authority. And very important here are the timelines. And this is actually one of the reasons why we, as I mentioned in the beginning of our webinar, that we launched this new hotline, legal hotline service 24/7. And part of the reason why we launched it is because the deadlines for notifications are extremely short. So the directive says that in case of a significant incident, the entity must give an early warning notification to the authority within, of course, without undue delay, but latest within 24 hours. This is 1 day. 24 hours, regardless whether it's a weekend, it's Christmas or whatever, within 24 hours of becoming aware of the significant incident. Of course, there is some interpretation room. The law says, or sorry, the directive says that becoming aware of the significant incident, there is some leeway in saying that there may some time was taken by the entity to understand whether the incident is actually significant or not. But still, the deadline is quite short. And within that early warning deadline, also information must be given to the authority whether there is any suspicion that this incident was caused by unlawful or malicious acts, and whether it has any cross-border impact. So meaning, for example, if there is an incident in Estonia regarding Estonian entity, Estonian hospital, for example, this early warning notification must also tell whether like other countries' patients are also subject to this incident, and whether the cyber criminals were behind it or not. Then the second notification which must be submitted is the called incident notification. This must be done also without undue delay and latest within 72 hours of becoming aware of the significant incident. The idea here is that the first one, the early warning, should be done like with less of a data, but this incident notification within 72 hours should already have more data. It should involve a lot of things. I will not go into very detail with that, but very important is that it should have an update, what has changed since the submission of the early warning notification. It should describe in normal language what happened, when it happened, like a timeline, what is the severity of the case, what kind of impact it has on IT systems, for example. Has the data been stolen by the cyber criminals? Has the data been manipulated by the cyber criminals, but the data is still on our hands? And so on, and how many users are impacted? Are we talking about, for example, the data breach of data of 100 people or 100,000 people? So this is the data that helps the regulator to understand the impact of the case, and also information. What was the reason, or what do we suspect was the reason for this serious incident? What is the plan to take care of this incident? What is the roadmap basically? And what kind of help is expected from the CSIRT? And this is actually a very important thing, that when we're talking about the notification to the CSIRT, is that it's not only the thing that you should notify the country or the government, so to say, because the law is so, but the very big upside of is that there are good professionals working in these organizations, in the CSIRTs, and they will help you. They will help you. They have a team. They will allocate their team's time to help you out in this serious incident, and this is why it's actually a very good thing. There are also a third kind of type of notification. So this is the third in the line, comes after the early warning and the notification. It's called an intermediate report. This must be done to the CSIRT if they request it, and as a final step, there is a final report. So within 1 month after the incident has finished, so to say, then there should be a submission of final report to the CSIRT. If the incident is ongoing, even during the 1 month period after starting it, then it should be submitted 1 month after the incident has finished. And this has to have like even more detailed information of what happened. And this is the part where you're not anymore speculating what happened, but you should actually know if it's possible, like with technical ways, as much as you know, specify what happened, why it happened, who were the criminals, were there any criminals, and so on, and what we did to overcome this situation, and what was the cross-border impact of that. So these are the different types of notifications. Also, these are not only notifications to the government, but under the NIS2 directive, in certain cases, also the users of your service should be notified of the serious incident. So, for example, if you're running a hospital, this would be the patients. The patients in some cases should also be notified of the serious incident, and thereby the essential and important entities have an obligation to notify the users of the service, as directive reads, where appropriate, and when it's likely to adversely affect the provision of the service. So it's kind of a vaguely sentenced obligation, but this is how it is, and when it should be done without undue delay. In our example, where patients' data was leaked to cyber criminals, most probably the hospital has an obligation to notify the patients as well under this obligation. Additionally, there is one important thing, is that when I mentioned that the entity may have an obligation to notify the users of service of the serious incident, then in some cases the public or the recipients of the services must also be notified in case of a cyber threat or a significant cyber threat. And this is basically the scenario where the incident has not happened yet, but we have a suspicion that something may happen, and the notification obligation is in a case where the recipients of the services that are potentially affected by significant cyber threat should be notified, and of course where it is appropriate. So, for example, if we are storing the credit card data of our clients, and the credit card data we are suspecting that they soon maybe or even are already being stolen, then we should notify our users. Why? Because then the users can mitigate the risk by closing down their credit cards. This is the idea of that notification, that people can actually take some measures themselves to mitigate possible damages what the incident may otherwise have. Or, for example, if you are storing usernames and passwords, and for example they are leaked, then again notification should be made, because then persons can change their passwords and criminals cannot get into their user accounts. And again, when without undue delay. Talking about NIS2 directive, we shouldn't forget about other types of notifications as well, because I'm sure that almost everyone here knows about GDPR, so the General Data Protection Regulation. This also and still has the notification obligation. Within 72 hours, the regulatory authority should be informed if it's likely that the data breach that the data breach may have a risk on the rights and freedoms of natural persons. So if you have an obligation under the NIS2 directive to inform the NIS2 regulator, and it contained also personal data, this is data that was, for example, leaked, then you have to also inform your local data inspectorate, so 2 notifications. And also under the GDPR, under certain rules, the data breach must also be informed to the data subjects themselves, so to the public and the users. And also very important, financial sector is under the regulation of DORA. DORA is similar to NIS2, but DORA specifically regulates the financial sector, and nearly all entities under the financial sector are subjects of DORA. So, for example, credit institutions, investment funds, insurance providers, you name it, they are probably under the DORA regulation. And DORA regulation, in addition to setting similar or actually even stricter rules regarding cybersecurity, also has notification obligations. And the latest when I checked it, it was 4 hours after considering the incident as major, and maximum within 24 hours of becoming aware of the incident. So the DORA notification periods are even shorter and even stricter. So it's important to understand that there are still also notification obligations from other laws as well. Asta, do you want to give a few words about regarding Lithuania, as we have a lot of Lithuanian listeners here, about the notification of a non-serious incident to the authorities?
Mm-hmm. Yes, I've mentioned Lithuanian specific is that you have to notify on non-significant incidents. Actually, Lithuanian regulation speaks about major and minor incidents. So the concept is used, such concept is used in the legislation. So the deadlines differ and the information that you must provide differ. I will not go into details, but just bear in mind that if it's not a major incident, you still have to report on it in Lithuania. Although I know that in Germany you don't have it, in Estonia you don't have it, so just that.
It's a particular, yeah, it's particular for Lithuania, I guess, yeah, because under the NIS2, you only have to notify the significant incidents. But again, NIS2 is not a regulation; it's a directive. So each country has some leeway on how to interpret it and implement it under its local law. But let's move on to the final subjects here today in our webinar. I will give the virtual floor to Rauno to speak about the enforcement measures and penalties. So a very, very juicy topic to end this webinar today.
Hi, everyone. Pleasure to be speaking with all of you on this fine morning. Anete tried to mislead you all in the beginning, saying that fines are not the most important reason why we're doing this. They are. We are only doing it for the fines to avoid them. No, actually, we will go through in a couple of slides what are the actual enforcement methods used by the local regulators. What can we expect in terms of supervision? What are the expected powers used on us as either essential entities or important entities, ending with fines? But there's a very long set of procedures that will go before any fines are administered, and most likely in the grand majority of cases there will be no fines, but other enforcement measures instead. And before I get to the actual slides, there was one point I wanted to make that regarding these enforcement measures and penalties. It's a strange area, cybersecurity, where it is quite often that we will have an incident, be it a big or small significant incident, where there will be a lot of damage caused to natural persons, to companies, etc., to privacy, but also financial losses, and there won't be a very clear breach of NIS2, in that it is very much possible to do everything perfectly, quote unquote, and still get attacked with a cyber threat, and that is perfectly normal, and the regulations take this into account, and this is important to keep in mind when you're looking at an incident and thinking whether or not I should notify. Always notify. Most likely the end result will be that yes, you did things, as long as you followed the directive more or less and the local regulations, you did things more or less correctly, but at the end of the day, if you have a criminal with a DDoS attack, it's not possible to get rid of it entirely. So while we are doing it to avoid fines, it's also not necessary to be afraid of the fines so much, because presumably we're doing the right thing. So let's get started. So first, let's cover what things to expect in terms of enforcement. So I've done a bit of color coding here just so that it would be easier to understand. In the actual directive, there are two different articles. I think it's 32 and 34, if I'm not mistaken. They're quite similar. The enforcement measures that you can expect, both as an essential entity, which would be EE, and both as an important entity, which is IE, they're very similar. They're different lists, so rather I put them together and mark them so that anything that's yellow, the important entities don't get. That is special privilege reserved only for essential entities. And then in a couple of places, there's some green, which are specific to important entities. And as you can see, ex post means after the fact. So these are things that actually make the enforcement less strict and easier on the subject. So let's get started. The first one, on-site inspections and off-site supervision. And as you can see, in addition to inspections off-site and supervision, for the important entities, the supervision off-site will be conducted ex post, so most likely after an incident, whereas the essential entities get an additional element, which is random checks. So if you're an essential entity, you have to be ready for the fact that the regulator may show up essentially at any given time, regardless of whether or not there was an incident or not. And secondly, security audits. The regulator will be conducting them. If you are an essential entity, they will be regular for all of the essential entities. What will be the span of that regularities will depend on local regulation, but essential entities will get security audits on a regular basis, whereas if you're an important entity, then it will be targeted and most likely follow some sort of internal logic of the regulator. Then a specific measure just for essential entities, ad hoc audits. So again, if you're an essential entity, you have to be prepared for the fact that the regulator will just show up out of the blue, conduct a security audit, and also conduct an IT audit where they find it necessary. Then a common element or security scans. These will be based on objective, non-discriminatory, fair, transparent risk assessment criteria. And if it's necessary, then the actual entity concerned will be brought into the process to make sure that those security scans actually give the full picture of the security level. Then I guess the most basic one that we can all probably expect and will be in contact with are requests for information. For important entities, they will be ex post, meaning that most likely most of the requests for information will come after an incident has been reported or has taken place or has been notified to the regulator. For the essential entities, these may come at any time. And essentially what that means is simply the regulator asking questions about risk management measures, cybersecurity policies, and more or less anything related to the actual physical compliance of NIS2. And then requests to access data, documents and information necessary to carry out their supervisory tasks. So if request for information will be answer these questions, then requests to access data might be logs, for instance, to see who has access to specific data or see web traffic or anything like this. And then if faults are determined, it's quite likely that the regulator will request both from essential entities and important entities that they provide proof and evidence of implementation of cybersecurity policies. How do we prove this? There are several ways, a lot of documentation, of course, but also interviews with key personnel, explaining how processes are carried out, diagrams of the software and hardware side, et cetera, et cetera, et cetera. So there's a lot of possible ways how we might prove implementation. So this is what we can expect. And then on this slide, it follows a similar logic of color coding. We'll just quickly go through things that the regulator will most likely do to us. It's quite a long list, but it's important to have an understanding of both what we can expect and what the regulator can do to us, because it informs the way we set up our internal procedures, because we have to be ready to comply with all of these potential requests and results. So what the regulator can do, issue warnings. So if they see a warning, if they see an infringement, they can issue a public warning about this, or to specific entities if needed. Binding instructions, so the regulator can go to an entity and tell them what to do in relation to fulfilling the requirements of NIS2. And then for essential entities, there's this yellow part, which simply makes the binding instructions more concrete and time limited. But essentially, I will say that the nature of the obligation is the same. Ceased conduct. If a regulator determines that we're doing something that we're not supposed to be doing, they can ask us to stop, and we have to stop. And this might be in relation to a very specific action, some particular technological solution that we're using that is causing the problem, or a business line that is causing a problem, or anything of that nature. And then the next one is the authorities can order the entities concerned to ensure that their cybersecurity risk management measures comply. So when Asta was talking about the risk management measures, then if they determine any issues with those risk management measures, they can force us to comply and make necessary changes. As Henri also covered regarding notifications, then the authorities also have the right to make you inform certain companies or natural persons that may have need of the information of any breach that may have taken place, which is similarly to the GDPR's logic. Oftentimes, the biggest deterrent from breaching NIS2 is not the fines, but rather the fear of partners and natural persons being notified of our breaches, and therefore bringing about quite a big PR problem. Let's put it that way. After incidents, the regulator might make recommendations, and they are obliged to order us to implement those recommendations. For essential entities, in case of a breach or a problem that the regulator has determined, they might require the designation of the monitoring officer, which will essentially stay with the entity and make sure that everything is done by the book after the fact. And then publication. If there has been a breach, it may be necessary to make some aspects of it public. And then finally, we get to the best part, which are administrative fines. NIS2 does have a special regulation for countries that don't have the option of applying administrative fines, it essentially says that you should do the next best thing. But this is especially relevant for Estonia because Estonia does not, in fact, have administrative fines. But the end result is more or less the same. There will be fines if certain regulations are breached. So what happens if I don't do it? So comply with, let's say, the suggestions and the orders, et cetera, et cetera, et cetera. So, and this is only for essential entities. The regulator has the option of suspending certification or authorization of companies. So especially if you're a legal entity that's operating on the basis of a license of some sort or needs authorization from some regulatory body, then it is possible to suspend that. And then also it is possible to prohibit specific natural persons from exercising managerial functions. So if the regulator sees that there's a management board member who simply will not comply with their orders, it is possible to prohibit them from complying, essentially. But it's important to keep in mind that these interim measures are only valid and usable until the necessary actions to remedy the deficiencies have been taken. So as long as you fix the problems, essentially, these bans, prohibitions, and suspensions will go away. An interesting element of NIS2 is that after the regulator has come in and said we have to do this, and this, usually you would expect the company to be liable, but in the case of NIS2, it's not necessarily only the company. NIS2 says that also natural persons may be liable for breaches of NIS2. So if I'm this management board member who is willfully and knowingly setting up a system in breach of NIS2, or I'm not complying with the orders of the regulators, then this may bring about liability. What the nature of that liability is will depend on also on the local legislation, but very important to keep in mind that this is true both for essential entities and important entities alike. So quite a good motivation to actually fix the cybersecurity situation, because next question. Is it possible that I'm not aware of any of this and suddenly somebody will show up and start issuing bans and fines? No, that will not happen. The idea behind this is rather that the local regulator will be working in dialogue with the entities, and the final goal is not to punish anyone, but rather to make the actual cybersecurity level better. So what will usually happen is that they will set out the detailed reasoning for any enforcement measures. You will get a notification of this, and you will be able to issue your own position on any of those enforcement measures as well, which the regulator hopefully will take into consideration. And as you can see here, you will have the right to submit observations before any measures are enforced, except for cases where it's time sensitive and it's not possible to give the entities the time to respond. But that how that will look in specific member states and what that administrative procedure will look like specifically time will tell. Finally, we get to the good part, and I know it's 11:30, so I will be very quick. But we've been waiting for this moment for a long time, and we're finally here. So how do I get a fine? The biggest prize of NIS2. So fines are given for breaches of two articles, 21 and 23, which are cybersecurity risk management measures and reporting obligations, which more or less covers everything. So if you don't have the necessary risk management measures implemented, or you don't report, then you may have an issue. The fines are different for essential entities and important entities. Essential entities, it's a maximum of at least 10 million or at least 2% of the total worldwide annual turnover in the preceding financial year. And this goes for the entire group. However, as we've seen from the GDPR, the fact of the matter is, in Estonia, there have been 0 fines enforced. They have been written out under the GDPR, but none of them have gone into enforcement so far. So what the actual effect of this is and what these numbers mean, it's hard to say. The local regulators doing this work will most likely be better funded than the ones dealing with privacy. I have a feeling like this for some reason. So what the level of fines will be, again, time will tell. Most likely, in Estonia's context, at least, they will be quite low in the beginning, but we don't actually know. We don't actually know. GDPR is a very bad benchmark for this type of thing. But we have to keep in mind that at one point, the European Commission, or well, they actually already are, European Commission will not stand for, at least in Estonia's case, this reluctance to actually hand out administrative fines. It's also quite a big political issue already, and at one point there will be a turn to more fining of entities. And for NIS2 also, the breaches are much more clear than in the case of GDPR. You either did have the measures in place or you did not. And then for important entities, of course, it's at least 7 million euros, 1.4, not the 2 that it is for essential entities. So this covers the fines. And then there will be additional penalties under local legislation. But as was discussed earlier, the Estonian legislation is not even in the parliament yet. So I won't actually even get into that because this is all up in the air right now. Very much. And that is it. I went over time with 3 minutes. I will remind everyone about the hotline. There was also a question in the Q&A regarding this, whether or not there is technical support. I don't know if anybody already answered this question, but I will quickly go over this. So the idea of the hotline is that we can respond to the calls and give first initial feedback as to what the game plan should be going forward. And if necessary, a client agreement could be concluded as a result of that initial feedback if necessary. In terms of technical support, we have good partners, both in Latvia, Lithuania, and Estonia, that we can recommend over the hotline. But we as a law firm do not ourselves provide technical support. But those contacts will come in handy, and certainly you will have them available through the hotline. But I would suggest setting up these technical contacts beforehand, immediately, knowing that if there is an incident, I have somebody to call already and not rely solely on the WIDEN Legal hotline for technical support. So I'll give it back to Henri for some closing remarks. And from my side, thank you, everyone.
Thank you, Rauno, very much. I know that we are a bit over time, but in the last minute, we had 2 more questions. I think if we are very quick, we can go over them. I think, Rauno, the first one is actually for you. The question is, what does it mean a maximum of at least 10 million euros? So the minimum amount is 10 million euros. So what does the at least mean there, Rauno?
So what that means is that the local lawmakers need to set up a system whereby it is possible to fine someone with a fine of at least up to 10 million. But they could, it can't be a regulation that says the maximum fine is 5 million, because that would be less than 10 million. It has to be all the way up to 10 million if necessary. However, if they want to say that the potential fine is 20 million, then go right ahead.
Thank you. And I think actually the second question is also for you, because it talks about liability. So the question is regarding international group. So if you have a group of entities, do they have to register to the local authorities? But how does this apply for a group entity? So how are the responsibilities shared between group and national entities in case of liability? You're on mute, yeah?
Yes, sorry. So my understanding of this, and Asta and Anete and Henri, feel free to correct me if I'm wrong, but my understanding of this is that each and every legal entity will be looked at essentially separately, and if breaches are determined in a legal entity, then they will be dealt with under the local regulations. It is possible that you will have a group of companies having subsidiaries in, let's say, 3 European countries, Estonia, Latvia, and Lithuania. And since they're all following the same internal policies, if a breach takes place, for instance, and it is determined that it is due to lacking internal policies, then it is possible that all 3 countries will be penalized in all 3 member states separately. But it's theoretically also possible that for some of those entities, it will be found that they are not in breach of NIS2 and will not be penalized because the local regulations are different. For instance, it was a minor incident, and in 2 countries, it is not necessary to report or something like this.
Yeah, that's true. And this is actually also one of the things that NIS2 is a directive, so it's not directly applicable. Directive is not directly applicable, ironical, but this is how it is. Directive is not directly applicable in each member state. If it would be a regulation like GDPR, for example, then it would be directly applicable. But as it is not, then each country has a bit different laws and regulations applying. So I guess this is also one of the part why each entity in each country would be separately liable if they would be found liable by the local regulatory and the local court if it would be a court dispute.
I just wanted to add
yeah.
that as I already showed that this is minimum harmonization directive, and Latvia have also their national differences and have added some specific subjects that falls under Latvian cybersecurity law as a subject. And for example, if it's not considered a subject, for example, in Estonia, it might be a subject in Latvia. Therefore, you need to be careful about group policies and not to apply to all your kind of businesses to all country the same. You still need to think that there might be and there are the national differences. Therefore, be careful about these big group policies that are like a ketchup on everything.
That's true. And actually, there is a question regarding Latvia for you, Anete, as well. The question is, did I understand correctly that in Latvia, both essential and important entities should have already been informed? And if you haven't received any notification, it means you are not a NIS2 entity.
According to the papers, the competent authorities should somehow reach out to you. But from my experience with the critical infrastructure, it happened just in one day. Many companies actually didn't know that they are owning a critical infrastructure. So it won't help you to tell the government that you haven't received any information. It's your own homework, actually, to understand if you are subject or not, because it will not help you if something happens and if you get a fine. They should ask you some kind of information, but it can happen in very last minute and it might be too late for you. So do your homework. We will be happy to help you, but don't expect that you will receive an invitation to be important or essential company or something like that. And please write me an email and I will be more than happy to take a look and help you.
Thank you very much, Anete. So to close off this webinar, thank you very much for participating. If you have any questions, if you doubt whether you are subject of NIS2, whether you have a data breach or cybersecurity incident, please call. The number is there. Or if you have any other questions, if you want to get help regarding the documents, regarding cybersecurity, etc., we are here for you. Our emails are on the slides. Write to us, call to us. We will be happy to help. And thank you very much for participating and have a great day.